My name is Kimberly Brown. I'm an African American female. I'm a mother of three children, a wife, a former United States Army paratrooper, and I hold an MBA. Like so many, I come from a humble background of little means, but I worked hard in order to give my children a life much different than mine. I created this video to share with you not only the discrimination I suffered at the hands of AT&T, but also the crime committed by the very federal agency charged with upholding laws designed to prevent discriminatory practices in the workplace. Despite the fact that under my leadership of approximately 369 telecom techs and managers, performance results improved by double digits. Overtime usage decreased. Attendance results improved. Labor contracts between CWA and AT&T were finally being honored, and administrative guidelines were followed. Despite all of this, with nearly 14 years of proven performance, including awards, an all-expense paid trip for me and my spouse, monetary rewards for performance during natural disasters, and a spotless track record over those same 14 years, and I do mean spotless. AT&T demoted me on May 8, 2013 from the position of a supervising director, general manager, to a non-supervisory project manager and sent me to work from home with no training after being in an assignment for only 8 months. Within days, I filed an internal EEO complaint and spoke with the department's senior EEO consultant, Kathy Baharamian, who failed to complete the internal investigation and requested that I remove race as one of the discriminatory components of my complaint. In September 2013, I filed a federal EEO Title VII discrimination complaint alleging that AT&T and the ABS senior management team, which is the department that I was in, including but not limited to Assistant Vice President Susan Clark, a white female, Vice President Roger Abadoji, a Middle Eastern descent male, and Senior Vice President Andrew Dzarevich, white male, discriminated against me based on race, gender, and subjected me to retaliation, which later included an involuntary separation under the auspices of a workforce reduction effort in December of 2014. On May 15, my attorney provided what I'm showing for you here on the screen, a formal rebuttal to the EEOC's investigative summary, and included in that rebuttal comparators and evidence of non-protected, similarly situated class members who were not treated the same as I was. Over the next 45 minutes, the evidence would demonstrate that AT&T's representative, Kathy Baharamian, submitted falsified material evidence documented within AT&T's position statement to the federal EEOC during an open investigation. The evidence will also demonstrate that AT&T's employee, Linda Williams, conspired with Kathy Baharamian in the creation of falsified material evidence during the open investigation. The evidence will also demonstrate that the federal EEOC's representative, Lucy Campa, failed to comply with its own processes by failing to disclose material evidence included as attachments to AT&T's position statement. And the evidence would demonstrate that by withholding written falsified comments provided by AT&T's representative, Kathy Baharamian, concealed material evidence. I'm sorry, not Kathy, but Lucy Campa. the EEOC's representative concealed these attachments from me within her investigative summary. Lucy Camper also failed to cite to evidence in the investigative summary in accordance with their processes, and also by not providing me a copy of the investigative file prior to issuing its final decision, and in doing so committed criminal fraudulent concealment of information known only by them, the EEOC, causing further damage to me and denying me the opportunity to overcome the burden of proof. On May 5th, and as you can see, I have the letter up here. On May 5th, 2015, the EEOC senior investigator, Lucy Campu, requested a written rebuttal to the EEOC's investigative summary. According to the EEOC's investigative process, located at eeoc.gov/federal/directives and at www.eeoc.gov/EEOC/publications. I have the document up here for you, the website. And so that you can get that entire website, I'll turn the camera this way. I'll try not to put my fingers in there. An investigative summary is a narrative document. I'm going to turn this so that you can also see this narrative document and what it means. The investigative summary is a narrative document that succinctly states the issues and delineates the evidence, addressing both sides of each issue in the case. The summary should state facts supported in the complaint file sufficient to sustain a conclusion. The summary should cite the evidence and exhibits collected. And I can tell you that did not happen. What does cite the evidence mean? Well, we know that it means making direct references or giving credit to the source document. What I'm showing you now is AT&T's position statement submitted by AT&T's representative, Kathy Baharamian, on June the 23rd, 2014. And on page 2 of the document submitted by AT&T's representative, Kathy includes here an attachment A. As you can see there, please see attachment A on page 2. And she also includes an attachment B. I have here for you the third page of AT&T's position statement submitted to the EEOC by Kathy Baharamian, AT&T's representative. So she includes here an attachment B. However, the EEOC never cited to any evidence collected, nor did they disclose in any manner evidence provided by AT&T to me during the investigation. The federal EEOC investigative process is governed primarily by MD 110. As a complainant in these procedures, I am required to overcome the burden of proof. However, overcoming the burden of proof is hindered when material facts, evidence, and documents are suppressed and concealed by the very agency legally obligated to conduct a fair and unbiased investigation into an allegation of discrimination. Here are the facts. AT&T's representative, Kathy Baharamian, yes, the same person who failed to complete the internal EEO investigation, the same person who asked me to remove race as one of the discriminatory components in my internal complaint, submitted AT&T's position statement to the EEOC again on June 23, 2014. And again, it included an attachment A and an attachment B. I want to show you that once more. Here you see an attachment A on page 2, and this is AT&T's position statement, as well as an attachment B provided by AT&T, the EEO manager, Kathy Baharamian. In fact, attachment A is an email communication dated October 5th, 2002, from Tammy Crone to Susan Clark regarding HR recommendation Kim Brown. Not only did the EEOC withhold this evidence, they intentionally suppressed specific direct content by concealing the following. They removed these words right here. Please see attachment A from their investigative summary, and see 11/16/2012 email attachment B. So again, the EEOC intentionally suppress specific direct content by concealing, please see attachment A, wording that would give rise to the document's existence. In fact, I never saw or received this email or the information contained in it. As you can see, I am not a recipient of this email. My name is not included on the to line. Had this material evidence been properly disclosed, I would have submitted into evidence the email an email communication I received from Susan Clark dated October the 8th, 2013 regarding HR final recommendation required courses, demonstrating that attachment A's content, I'm going to bring that back up here just quickly. I'm holding it here so you can review this. Specifically, attachment A's content, disciplinary counseling details, expectations, or consequences were not included on the October 8th email (2012) email, and thereby negated AT&T's assertion that I received the documented coaching as stated in the EEOC's investigative summary. Had I known of AT&T's attachment A, I would have requested that the EEOC conduct a face-to-face interview with Susan Clark on the penalties of perjury. regarding the email